work comp are at the same level right now, right?
Nothing.
Nothing. So thank you for doing this for us.
Thank you
I
very
look forward
much,
to learning.
Jeff. It's so nice to have you all here. Welcome. Before I jump into my presentation, Sylvia Fuentes had an announcement she wanted to make.
Yeah. Hi everyone, my name is Sylvia Fuentes. I'm the Event Education and Outreach Manager at Pinnacle Assurance. We have one more in-person training happening on Friday, November 7th here in our office. This is for our workers' comp basics training. It's a really neat opportunity to be in a room with Pinnacle's subject matter experts, and they're going to be covering all kinds of topics ranging from claims, underwriting, auditing, subrogation, and it's also a great way to hear stories from other policyholders. So you may not be the audience. It is geared specifically to office managers, HR professionals. I would say, yeah, maybe some safety risk managers. It makes sense. So it's completely free from 9 to 3 on Friday, November 7th. You have a flyer right in front of you. If you can't make it to the in-person, we do have one more online training, and that's taking place on Friday, December 12th. Again, these resources are available to you. You don't have to have a policy with Pinnacle Assurance. We want to make sure that we are sharing education when it comes to workers' comp. It keeps everyone safe, and that's good for all of us. So we hope to see you there. You'll see that QR code on that flyer, and you can get registered there or share that. If you have any other questions, I'll make sure to leave them with my business cards. I'm happy to connect. Thank you.
Perfect. Thank you, Sylvia. Hopefully we'll see some of you there. Again, welcome. Thank you for being here today. I have been told I have kind of a softer voice, so if you can't hear me, please let me know. And Jessica, I told her, let me know if she can't hear me. But I'll do my best to keep my voice up and make sure you can. All right, so today we are going to talk about the legislative changes that were made and implemented in both in 2024 and 2025. I did the 2024 changes that went into effect in 2025, so I thought we'd cover that as well. I will get to 1300. There's a few things I wanted to cover first, just to make sure everybody's aware of all the changes, because there have been a good number. All right, but let's get rolling on it. Sarah, you want to do the next slide? Our sketchbooks. All right, next one, please. Okay, the first change involved House Bill 241220. That went into effect on August 7th of 2024, so this has been in effect for about a year now. There were several changes that were made under this particular bill. The first was to statute section 8-42-105, 4B1 and 1.5. It's all on there. And just so you know, I will send the slides out. I've got a PDF of them that you guys can all have afterwards, so that you'll have these in the numbers, because that's a long one to remember, right? I can't. But this change affected TTD benefits. Under it, an injured worker's refusal to accept an offer of modified employment is no longer grounds for termination of TTD benefits if the offer requires the worker to drive 50 miles or more each way than they did pre-injury. So if you give them an offer of employment, an offer for modified employment that expands the amount that they have had to drive from before, they can refuse that offer of employment, and there's no penalty to them for doing so. It's also not grounds for terminating TPD if it requires the injured worker to drive anywhere and the designated provider, the ATP, has restricted the injured worker from driving. So they've just said it. They've codified that, you know, if you have a situation where the doctor has said the injured worker can't drive, they can't give them an offer that's going to require them to do so. And if that does come in that way, the injured worker has every right to refuse that offer. And it's just a protection they put into the statute for the injured worker.
That only includes driving as part of the job functions, not getting to and from work?
No, I think it doesn't specify, so I would interpret it as getting to and from. So if you put them in a place that's that far away and they have to suddenly drive there, no, that's not going to work. Go ahead.
How does it affect for roving employees? So we have caseworkers that drive across the area.
Well, I mean, I think that's gonna be a specific situation that's not expressly addressed by the statutory change. But if you have that situation, I would think that if you have a doctor saying that the person can't drive because of their injury, then you're not gonna have a caseworker who's gonna be driving around to different locations. That's just not gonna be part of the job offer you're gonna be able to make to that person, because they're not gonna be able to do that, right? Yeah.
So if the modified duty position's at the same location as a regular duty position, but they're required to drive into work every day,
Well,
does
it's
that
only
change
if,
things?
it's only if the new requirement requires them to drive 50 miles more in each direction than they had to drive
But
before.
the other one said below that, it says it requires to drive, and they have a driving restriction. So
If
if they have a
that
driving
does-
restriction, they can't drive to work, but they're required to be there.
It's, you know, it doesn't specify either way. I would interpret it as saying that they can't be required to come in if they can't drive.
Because you have to get there, I mean, during your regular job, you have to get there, whether it's bus or driving yourself or whatever, you have to get there. I mean, if they get a driving restriction, all of a sudden they don't have to come into work?
The statute is pretty broadly written, so
Okay.
that it could be that, and it hasn't been tested. And you gotta remember, this is statutory language. Right now, all we can go off of is the plain language of the statute, and that is what
Right.
it says. If it requires them to drive and the doctor says that they can't, then they can decline the offer of employment,
Okay.
modified employment. And so until it's tested and somebody says, well, hey, they were coming in before and the job requires them to be here, we don't know. We're gonna have to go off the language of the statute, and that is what it says.
Okay.
Okay. Any other questions about that one change? All right. We'll do next slide. Okay, the next one. Under the same act. So this act, 24-12-20, affected several different statutes. So that's why it kind of like dropped little things in all over the act. So the other thing it did was under statute section 842-107C.5, which addresses scheduled and non-scheduled injuries. Effective August 7th of 2024, it added that the total loss of an ear was added to the list of injuries eligible for medical impairment benefits outside of the schedule. So a loss of an ear is no longer just a scheduled injury. Small change, but you know, you just need to be aware of it should you have that situation come up. Okay, next slide, sir. And under 842-107.5, this is under TTD caps. This was an important one. So effective the beginning of this year, effective January 1st of 2025, the statute increased the combined cap for TTD and PPD benefits from the previous cap of $75,000 to $185,000 for claims with impairment ratings of 19% or less. And it increased the cap from $150,000 to $300,000 for claims with impairment ratings greater than 19%. And just to be clear, it's effective on claims that were filed after January 1st of 2025. So if you've got a claim that was filed anytime in 2024, you're still under the old caps. But any claim filed this calendar year or forward, we're under the new caps, which are considerably better. Any questions about that? All right, cool. Next slide, Sarah. The other change was on to, well, this was an addition. This was a brand new statute that they added as part of HB 24-12-20. It's 842-127, and it now allows direct deposit. That means that an injured worker can say, you know, here's my bank account. I want my disability checks to be directly deposited into my bank account. You don't have to send it to a check in the mail to me, or you don't have to send the check to my attorney, just direct deposit it. I will warn you, we're having kind of a battle right now, the legal department is with some of the claimants' attorneys, because we've now been receiving requests that the direct deposits be made into an attorney's, what we call COLTAF account. That's like the attorney's account that holds their trusts of their client funds. And we've been ordered to do so and are doing so, but we're gonna fight it and see. That's a measure that's not clearly addressed by the statute. The statute says it can be deposited into any bank, savings and loan, credit union, et cetera. It doesn't say any bank account. So we'll see where we land, but I think that's something to keep an eye out on it, because it's one thing that we're gonna fight for that, because we just don't think that that's. The idea of it being about claimants of money being deposited directly into their attorney's account so that they don't have access to it just doesn't strike me or anybody else in the legal department as a good idea. How that helps claimants, I don't know. Helps attorneys, that's it. But I'll keep you posted. We'll see if anything comes of that. It's right now making its way through litigation. It'll be a while before we have a final decision on it. All right. Any questions about that? Okay. Next slide. All right, we'll move on to 1300. This one is the biggie. So 1300 was signed by Polis in June of this year. Okay. Polis only signed it because the sponsors agreed to amend it to push back the effective date until 2028. So this is something that we're not even going to see for another nearly 2.5 years. And between now and then, it's possible, maybe even likely, that there'll be changes made to it. There's no way for us to know. There's discussions happening right now with the division. They're having what they're calling listening sessions, asking for stakeholder input on what changes they might want to consider. But as it stands, this is now the law in Colorado, and we'll have to presume for now that what it requires, we're going to have to implement at the beginning of 2028. So, okay, next slide, Sarah. Okay. The first, this is kind of a minor change, but it made a change to section 842-101-3A1 A and B, and it just required that an insurer or an employer has to use the division's utilization standards when responding to a request for authorization from a treating physician. Small tweak, but just you need to be aware of it, that they're going to have to go, you're going to have to look at those utilization standards when you're looking at requests for authorization. Pretty straightforward. Okay. Next slide. Thanks, Sarah. All right. 842-101-5 was also changed pretty dramatically. First, it expanded costs liability to all contested medical benefits claims, not just claims for maintenance medical benefits. So, the way the statute worked was, if in the past, if somebody made a request for maintenance medical benefits, and the insurer either denies them, or it went to hearing on that issue, or an application for hearing was filed, and then it was later found that maintenance medical or Grover benefits were awarded, or the insurer decided to admit to them less than 20 days before any scheduled hearing, then the insurer was responsible for the injured worker's costs, which includes like expert fees, expert medical fees, that would have been incurred to go to that hearing. They made what sounds like a minor tweak. They deleted the word maintenance. So now it just says that you're going to incur the costs under these conditions anytime somebody asks for medical benefits. So rather than just Grover, it's been expanded to any medical benefits. So you need to be aware that if you deny medical benefits and the other side files an application for hearing, or you file an application for hearing, and then it's either those medical benefits are subsequently awarded after hearing, or you decide to admit them less than 20 days prior to the hearing, you could be on the hook for all of the costs that the injured worker has incurred trying to get ready for that hearing, including things like expert medical fees. So it does definitely expand how much you could be on the hook for costs in that situation. Any questions about that? Because that's, it looks like the subtlest of changes, but it has a huge effect. Okay. All right, everybody understands that. Let's move on to the next one. Next slide, Sarah, thanks. All right. This is the big part of House Bill 1300. This was the part that the workers' comp bar really wanted to get, and they did, which is physician's choice for injured workers. So under 1300, basically, injured workers now have a huge choice of who they can turn to as their authorized treating physician, their designated provider. The statute specifies a bit how it's all going to work. First of all, the division has been tasked with keeping a list of authorized treating providers from whom injured workers can choose. By our estimations, that list is probably 1,200 providers long. It's huge. So it was argued that this is going to be a little burdensome. How is an injured worker going to go through this long list and pick out the best provider for their needs? But that was ignored, so it's been signed. And now they'll have this long, long list to choose from. The list is going to be narrowed a little bit to only level 1 and level 2 accredited providers. So we do have that protection in there. They have the providers on there have to be level 1 and level 2 accredited, and an injured worker cannot choose somebody who does not have that accreditation. Pragmatically, the way it's going to work is the employer insurer is going to get notice of the claim, and then you'll have 7 days, 7 calendar days. Business day, big changes, so it's calendar days, so 1 week, to notify the injured worker of their right to choose a physician, and a link or an indication of where they can go to find that list. So we'll be sending out essentially a letter or some other form to the injured worker saying, hey, we're sorry about your injury. We know, you're feeling badly. We know you need some treatment. You have the right to go out and choose a physician of your choice. Here's the division's website. Here's a link to it that you can go to and look up the physicians that are available to you. That has to go out, like I said, within a week of notification of an injury. There are some kind of spatial limitations on how far away that doctor can be. It's pretty big. The designated physician has to be within 70 miles of the injured worker's work or home address, unless you're in a rural area and there are 3 or less doctors that meet accreditation level, and then they can have a 100-mile radius. So theoretically, if you have an injured worker who's kind of standing in the middle of the Front Range in Denver, they could go 70 miles to Fort Collins, 70 miles to Colorado Springs, and that doctor be allowed. So, we anticipate, some claims for mileage reimbursement. Yeah.
That's what I was gonna ask
Yeah.
you. The mileage reimbursement's gonna be huge if that's the case.
It is, yes. Now, one thing we've been tossing around amongst ourselves in the legal department at Pinnacle is that what the statute does not say is it doesn't say anything about an employer or insurer's opportunity to make recommendations to an injured worker. So we're kind of thinking that you'll have to notify them of their right to choose, but you can say, hey, we have experience in this area, whatever, knee injury, shoulder injury. Here are the best docs, in our opinion, to treat you for that. So we think that we're going to be able to include that information and kind of try and direct them a little bit, but it is still their choice whether they decide to go with one of those recommended doctors or one that they want. Yeah, go ahead.
What would happen if your injured worker happened to choose a doctor outside of that 70-mile limitation? by accident, whatever.
I
Does
mean,
the statute, does this talk about that?
it does not. So, I mean, I think under that circumstance, based solely on the statutory language as it is, and understanding that it's not implemented, so it hasn't been tested, I think we'd fight it and say, look, you pick somebody who's, 150 miles away, no, we're not gonna pay for you to drive 150 miles each way to go to this doctor. Whether that stands up or not, I don't know.
Right, so I was thinking being up in Fort Collins, if somebody chose a doctor, say Centennial, wherever,
Yeah.
it might be more than that 70-mile radius
Easily.
from
Right.
Fort Collins. And how's the injured employee supposed to know? They're gonna have to get on to Google Maps and figure out how far
Yeah.
the dock is from their house?
And I don't know the answer to that question. One of the issues that we're having with implementation is that the division's lists are not very good right now. They're not updated, they're not cross-referenced, so they're gonna have to do some real work on their end to get that up and running. And part of the bill does require the division to create a department essentially that's gonna be in charge of maintaining this list. I don't think that's happened yet. In these listening sessions that they've just started holding. There's another one coming up on the 22nd and then on November 5th. When asked that question about, what are you doing about rulemaking? How is this gonna be implemented? The answer back was, well, we don't think we're gonna need to look at it until the fall of 2027.
Oh my goodness.
Yeah, that was kind of our reaction. And, Wes Parham, who handles a lot of the legislation for Pinnacle, actually made a comment in response and said, geez, that seems like a really, that's kind of a little close, division. Maybe you want to do it a little bit sooner so that we have some time to take a look at this and work on these a little bit. But whether they do that or not, I don't know. That's going to be entirely up to the division. We've definitely made the suggestion to them that 2027 is pushing it out a little bit too far. But, yeah.
Do we know if it's driving miles or map miles? Because you can get mail 7
Yeah.
miles in the map.
I don't know. It doesn't, it just says miles. My understanding is when the Court of Appeals has interpreted something that just says miles, they've basically done a radius, drawing a giant circle. So I think, go ahead, John.
Again, being up in Fort Collins, what happens if one of our employees, we have employees that live in Cheyenne, Wyoming. What happens if they pick a doctor somewhere in the middle of nowhere, Wyoming? I don't know, 70 miles from Cheyenne?
Yeah.
But they wouldn't be on this designated list of providers in that case.
I think that's right.
Right?
I think our designated provider list is limited to Colorado doctors. I think. But again, it's not really
But there
updated.
should be nobody from Wyoming.
Speaker question. So if the bill says physicians, can it be a provider or can that change to a chiropractor for God's sake? Like they're
That's not entirely clear yet because, I'll come to it later, they changed another provision, expanding
Yep.
the number, or the types of professions that can be level 1 and level 2 accredited.
Yep.
So I think it says physician, so we're hoping it'll be limited to that. But, on the other hand, they did expand level 1 and level 2 to all these other things, including things like, I think it included veterinarians and athletic trainers. I mean, it was kind of, it cross-referenced it with Title 12. We'll come to it. But, yeah, so it's a little unclear. All right. Okay. Some other minor point, they put in the statute that the designation is gonna have to be made in writing on a form that the division will provide and create, which they haven't done yet, so I don't know what that's gonna look like either. But they've got 2.5 years to come up with something, so they're dragging their feet a little bit on that one. And the injured worker can make the designation on the form, using that form, at any time up until MMI. So they've got a long window to do that. So you could have them treating with somebody and they've been going along just fine and they're gonna be up at the point of MMI and they say, no, I've never made a designation, I'm gonna do it now. because, you know, they might not want to be an MMI, they want to extend it. But they have the right to do that. They're allowed to make that designation at any point up to MMI. So, we'll see how that goes. Next slide, Sarah, thanks. All right. There is a provision in there that allows an insurer to make a designation in the situation where the injured worker has not made the designation within 7 calendar days of receiving notice of the right to do so. So you get the date of you get the notice of the injury, you get 7 days to send out your notice that they can make a designation. Another week goes by, they don't do it. Employer can then make that designation and let them know. Now, that doesn't mean they get to have that will necessarily remain the position, because the injured worker still has the right to change. So they built that in there as well. So in addition to designating, they get a one-time right to change the position, whether they originally designated it or whether the employer designated it. And that's available to them within 120 days of the first designation. So it gives them a good big window to do that by right if they want to. And it's a little, my interpretation of this, because it says 120 days or up until MMI. So I think the way they've interpreted that is, you know, if you've got the first 120 days, or if they hit MMI within that 120 days, MMI cuts it off. But it's not spelled out entirely clearly, but I think that's the only way you can kind of harmonize all the language that makes sense. In addition, if you've got a situation with a non-resident injured worker, like somebody in Cheyenne, then the employer has 10 days post notice of the injury to do the designation. And that designation has to be within 100 miles of the injured worker's home. So I think that answers your question then, Jeff. That if you have an out-of-state worker, the employer is going to be the one, the insurer is going to be the one doing the designation. And then if the employer does not make such a designation within that 10-day window, it reverts to the injured worker to do so in writing or by attending going to an appointment. So they made it really easy for the injured worker that thing. So if you got an out-of-state one, an employee, 100 miles within that employee's work home, and must be done within 10 days, or it reverts to the injured worker to just go to whoever they want. And then lastly, if they just put in a provision because insurers expressed a concern that if, you know, this is going to give a lot of leeway to claimants' attorneys, right, who are going to be presumably directing their injured workers to particular physicians. So they did throw in that the council cannot direct the injured worker to a physician or a physician's practice in which the attorney has a financial interest. Which, I mean, I don't know how many attorneys have financial interests in doctors or physicians, but it's a slight bit of protection. Do anybody have any questions about it so far? Or? The one other thing I wanted to note is, just so you know, when the bill was first introduced, it had a provision in there that would have shifted the burden to the insurer and employer to prove that any request for authorization for treatment was not reasonable and not necessary. Right now, it is the injured worker's burden to prove the necessity and the reasonableness of any requested treatment that they want. So they were going to shift that around and make essentially a presumption that any treatment requested or recommended is reasonable and necessary unless the employer had proved it wasn't. That provision was thrown out because the sponsor realized that they weren't going to get it passed if they left it in there. But I am wondering, you know, if they wanted it, they might try it again. We don't know. And maybe it'll go through the second time. But it was thrown out for now, it is not part of it, but there was discussion about putting in this burden shifting. All right. Okay, that is 1300 in kind of a nutshell, all the different changes to it. Not going into effect anytime soon, but a lot to be aware of. So, any questions about it? Anybody want?
Just to throw out a thought, what is Pinnacle's thoughts on what's this gonna do to workers' comp here in the state? Is it gonna drive, it's gonna drive up
It's
costs,
gonna drive up
delays?
costs substantially, we expect. One thing is, with the imposition of the injured worker freedom of choice, right? That kind of takes away our ability to rely on our select net, right? We had the way the statute had worked is you made a recommendation of 4 possible physicians to whom the injured worker could go. And if you chose from the insurer's network who those doctors were going to be, you got a discount on your premium, right? 2.5%. That's probably going to go away too, because there's not going to be any way to maintain it, and they have essentially negated it. So yes, cost of doing business in Colorado is probably going to go up because of this. So yeah, the premiums are going to go up. There's measures in there that are going to increase costs. If they're asking for medical benefits and you lose, you suddenly could be responsible for paying for their costs. You're going to see more mileage expenses. It's going to be very cost intensive for sure. Yeah.
What if physicians don't want to do this? And an example is like Kaiser doesn't do workers' comp. Like, can the division pull 1,000 guys to be on the list, and then you schedule and they say, I'm not going to see you? Like, that's going to complicate a lot.
Yeah, it could. I don't think, first of all, they can't force anyone to be on the list, right? They can't force somebody to be level 1 and level 2 accredited to be on the list. They don't want to. They are hoping that this will actually expand the number of physicians who want to be on it, because they've done the upcoming changes to the sunset provision that expanded the number of providers that could be covered. I think they're hoping that will expand the list, because we've had an issue with the number of available physicians decreasing. So they are trying to increase that, and they made some other changes in the rules about how rates, reimbursement rates for physicians that they're hoping will also entice them to be more willing to be on the list. But ultimately, only the doctor can decide whether they want to be on the list or not.
Is there anything in the proposed language that requires the level 1s and level 2 to have any type of education on how the paperwork works with the work comp system?
I don't know about the paperwork. There definitely is.
And case management
yeah.
and all of that, that's really important.
There are qualification requirements. I don't know the paperwork is part of it though, but yeah, that makes sense.
Well, that was a question at CDAA this week, is orthopedics, they don't want to be a gatekeeper.
Right.
And so if someone chooses an ortho as their doctor, that ortho's not going to want to write restrictions and be the gatekeeper.
Mm-hmm.
So then, what do they do then?
Right.
So,
Exactly. What if they choose a chiro?
yeah.
Yeah, lots to
Darren,
see
you
how.
got any comments on that?
All right, any other questions about 1300 before we move on?
Why does it start with a 13?
That is a question for the legislative
It's
aid.
a joke, but it's terrible anyways.
But makes it so easy to remember. Okay, let's move on to the next slide then.
Alenka, we're gonna give you a mic real quick.
Oh,
Is that it working?
so hard.
You're doing great. And testing. Is that better?
Okay.
Okay.
Oh, that makes me much more yeah. Okay, can you, assuming you can hear me now just fine? Okay. So as I alluded to, one of the other changes that came through in 2025 was the update to the sunset provision. This was 842-101. It was supposed to sunset on September 1st of 2025, and it's been extended now to September 1st of 2036, so another 10 years. What it did is it expanded the list of healthcare providers who are eligible for level 1 accreditation to any provider governed by Title 12 and listed in the division's utilization standards. The utilization standards, just so you know, are set out as Rule 16. And it includes quite a long list. Just by example, Rule 16-2 subsection N includes acupuncturists, nurse practitioners, audiologists, athletic trainers, social workers, massage therapists, occupational therapists, physical therapists, marriage counselors, pharmacists, durable medical equipment suppliers. So all those people are now going to be allowed to get level 1 accredited if they so choose. Don't know how many people take them up on it, and I don't know what effect it will have in the end on, what kind of treatment injured workers can get, but the list has been expanded. Kind of crazy, right? But now, if you pull up Title 12, it's this very long list, and then Rule 16 is this long list, and you're like, wow, okay, here we go. All right, any questions about that?
You said it extended the expiration date to 2036?
Yes, the sunset, yeah.
Awesome.
So it's just that means that the statute needs, in 2036, they'll have to re-up the statute. It just means it automatically would go out of effect on that date if somebody doesn't act.
What's the thought process behind having a marriage counselor, social worker, athletic trainer be a level 1 accredited?
Boy, I wish I knew. I mean, in some of them I can get. Like, I can see you want an audiologist if somebody has a hearing loss, or a massage therapist if you got a neck injury or something. Marriage counselor? I don't know. You have a, I don't know.
Seems like a personal issue.
That is a mystery.
Yes.
All right. Okay, let's move on to the next one. So let's go over, there were some rule changes as well that you need to be aware of. So these are changes to the workers' compensation rules of procedure. First up, you've got some changes to Rule 7. This is affecting closures of claims. They were minor tweaks, and I don't think they're going to make any big difference. There were things like they updated and increased the life expectancy tables by about 2 years. The general rules for governing closure remained unchanged, essentially. You can move to close, just so you know, move to close if there's no activity for 6 months and the injured worker is not receiving TTD. So if you've got a claim that's just sitting out there and nobody's been prosecuting it and 6 months have gone by and you haven't heard a peep out of them, you can move to close as long as they're not getting TTD. But then that's something that's happening in the claim, so it's obviously not no activity. You can also close by an FAL if the injured worker is not receiving TTD and the injured worker has not attended 2 or more scheduled medical appointments, failed to respond to correspondence requiring them to do so within 30 days, and that letter was sent after the second missed appointment. So basically, if you've got a situation where you've got an injured worker who is not responding, isn't attending appointments, you schedule the appointments, and they miss one, and then they miss another, schedule 2, you can send them a letter, and if they don't respond to that letter within 30 days, so they've now missed 2 appointments and failed to respond to your letter, you can file an FAL to close it. That's basically the injured worker telling you that they're not interested in proceeding, and that's how the rules would interpret it. In practice, I don't know that that always works. My experience has been if you've got something that's been sitting around for 6 months and nobody's done anything, you suddenly file a motion to close, you're essentially poking the beast, right? And then you get a sudden flurry of stuff from the claimant's attorneys or the claimant saying, oh, no, I didn't mean to do that. filing my app for hearing? No. But, you know, it's possible. The option is out there, so be aware. Okay. Next slide, Sarah, if you can. There's also a few changes to Rule 11, the dime. This was in effect of April 1st of 2025. So these are brand new, so you may have already encountered this. But there were first of all, some changes to the qualifications for dime providers. They now have to have 384 hours of direct patient care over 10 years and demonstrate competency through board certification or equivalent. So the dime physicians can't be just anybody. They have to have the right training, qualifications, and experience to do the dime. They just also changed some deadlines. Like, it used to be that it was 5 business days, now it's 7 calendar days. They just were trying to make it easier for people to calculate. So no matter what, you have a week. Now, the one thing to bear in mind is if it falls on a holiday, you're still gonna go to the next day. So, you know, if something gets filed, you know what, a week before Labor Day, and your 7 days is on Labor Day, you're gonna do it on that Tuesday after. But other than that, things are gonna be a week. And you've got that time to strike one of the 3 proposed dime physicians. Okay. Okay. Oh, next slide, Sarah, if you don't mind. Right one? Yeah. Okay. The insurer has 30 days from the date of the notice and proposal of application for a dime to deliver the medical records to the division. The division will then deliver the medical records packet to the parties and to the dime no later than 14 days pre-dime. So it used to be that we had to provide them, right? But now the division is going to take all that internal. The divisions will be creating a medical records unit that's going to be in charge of collecting, organizing, and sharing medical records for the dime process. And it'll make things easier. So, you know, we always had to, you'd have to organize them, have them in chronological order or reverse chronological order. Now you can just hand them over and say, "Here, division, it's your problem." So that'll be a little bit of a savings, I think. They've also imposed a burden on the injured worker to notify the insurer at least 2 weeks before the dime if the injured worker is going to need an interpreter during the dime. And the insurer is responsible for arranging for the interpreter and paying for the interpreter. But they can appear virtually or by audio if that's easier. Finally, the big piece is the fees for the dimes. The way it's now structured, the party requesting a dime pays the first $1,000 of the dime physician's base fee unless the injured worker is indigent. But the remainder above that $1,000 is paid by the insurer. So only $1,000 was ever going to be charged to the injured worker on any dime, and everything else the insurer carries. I'm sure you've had some experience with this already since it went into effect in April, but does anybody have any questions about that?
How do you get notified as a respondent? Is the division doing that?
About what? About interpreters?
About paying the balance, whatever's has to be paid past the $1,000.
Sarah may know that better than I do. Jessica?
We received notification from the division.
Okay, thanks.
What needs to be paid.
Yeah, so that's been happening already. But yeah, just a few months, but lots of expenses. Any questions about that one? Okay. Let's go to the next one. This is the Rule 16 utilization standards. These went into effect January 1st of 2025, so this is new for 2025. It eliminated the long-standing requirement that a physician personally examine an injured worker in person within the first 3 post-injury visits. So now, it is okay for for an injured worker to be treated by a nurse practitioner or a PA, unless there's a physical need, a medical need for a physician to look at the injured worker, or one of the parties has requested that the injured worker be examined by a physician. But it's not required anymore. It used to be that the injured worker had to see a physician within those first 3 visits, and that's not the rule anymore. You can go ahead and have them seen by a PA or an NP. Yeah.
Would 1300 change that back? Because if they only allow physicians, right?
I don't think so. So, I mean, we'll see what changes they made, but I don't know that they've thought that all the way through yet, quite frankly. And this rule just went into effect. So I think they'll see how it plays out, and they've got a little bit of time. 2020, 1300 isn't until 2028. So, but I don't think so. I think they were trying very hard to use this as a measure of keeping costs down and making more providers available to injured workers, because they were having so much trouble having enough for the injured workers to get to. Any other questions about that one?
So you said that either party could request that they be seen by a physician?
Yes. Yeah. So if there's some reason you think that the injured worker needs to see a physician, you can request that.
What are the requirements for that then? I mean, could be anybody?
I don't know specifically. The rule doesn't specifically say. I mean, I would assume level 1, level 2 accredited, but it doesn't
Do
specifically.
we have a standing order that we want all of our employees seen by a physician? That's our request, that every one of our employees is seen by a physician within the first 3 visits, as they always have been.
We don't.
I mean, if we can request it, then what's stopping us from doing that?
Nothing.
Okay.
Yeah. I mean, cost, I suppose, but
Well, it's not gonna change our cost.
no. I mean, honestly, this was more aimed for, like rural areas where there's not necessarily a physician available, right? There's
Yeah.
so many of those remote areas where the best you can do is get to an NP. So they wanted to make that a treatment option for injured workers in those situations. I think that's really what they were aiming at. But it is broad enough that anybody in urban areas could be covered by it as well. Okay, next slide is we're going to talk a bit about Rule 18. So, Rule 18, they've made changes twice. This first one went into effect in January of 2025, so it's already in effect. This was changes to the medical fee schedule. Basically, payers must now reimburse providers without an associated fee. They made this weird change that prescriptions for gabapentin specifically have to be filled through a pharmacy. Doesn't say anything about other controlled substances, but just gabapentin. It implemented some conversion factors at an established percentage of the Medicare reimbursement and upped the ambulance transportation reimbursement cost by about 50 cents. So small tweaks, but already in effect. Nothing major. Okay, next slide. Then this year they tweaked it some more, and these are going to go into effect January 1st of 2026. These were just adopted. They had the rulemaking hearing about this just last month. So this is brand new. And the changes I don't think are going to affect insurers all that much, but you need to be aware of them. It added a list of documents which psychiatric and psychological services have to include when they're evaluating a patient. Have to list the symptoms or the lack thereof, have to address the worker's cognitive functioning, the activities of daily living, the nature, purpose, and content of any communications with the family members, what psychotropic or related medications were prescribed for the patient, what lab tests were ordered and reviewed, a review of the treatment history and future care recommendations, and if used to complete an impairment rating, the functional deficits of that patient. So this comes into play, like I said, in psychological and psychiatric services, and they have to provide all this information when they're evaluating the patients. All right, next slide, Sarah. Okay, and then lastly, it increased rates for some cares. Just so you know, there are higher rates for inpatient facilities, home care services, some different kinds of therapies like antibiotic, chemotherapy, fluid therapy, pain management, and certain prescriptions and over-the-counter medications. So it increased the reimbursement rate for all those. So just be aware that you need to look at the new rule to get the most updated reimbursement rates. It also made one change. There's an additional reimbursement permitted for travel greater than 50 miles. It used to be that if it was an hour more or more in each direction, and now they've said 50 miles. If I were to read the minds of the rule makers, I would think that they're looking at this thinking, well, sometimes you're stuck in traffic for more than an hour, so if you've only gone, 5 miles in an hour because you're stuck in traffic, that shouldn't count. So now it's 50 miles, so they've increased it so to take out that traffic stop. They also did a bunch of updating of code references. I'm not even going to pretend to know what all those are. It was very confusing to me, but if you have to deal with codes for reimbursement, know that some of them have been updated and you'll need to look them up. And then just lastly, you no longer have to get the division approval to use a qualified interpreter if no certified interpreter is available for any language but Spanish. So you can just find a qualified one, you should be good to go. And if you're dealing with Spanish, if there's no certified interpreter available, the provider can supply a qualified interpreter, but then the interpreter has to be separately reimbursed. So, not sure why that change was necessary, but there it is. Okay, that's it for the changes for Rule 18. Any questions about those real quick? All right, and last, I was following up with Michelle Sisk, Judge Sisk over at the division, and she let me know that they plan to go over rules 1, 5, 6, and 7 in early 2026 to bring them into compliance and in line with EDI 3.1. They're going to be more extensive changes, tweaking to make sure the language is, all conforming with what needs to be there. They anticipate holding some stakeholder meetings in early 2026 and are seeking input on any suggested changes. So if there's something you think needs to be done to those rules, the division is listening and is interested and welcomes your input on those. But look for that in early 2026. And that's it. All right. Any other questions about any changes upcoming or already made and in effect? Okay. Thank you all for coming. Thank you for being such an attentive audience.